Hello, hi. இன்னைக்கு நம்ம பார்க்க போறது business law. This is a CA portion. This is paper 2 and this is chapter 1, unit 1, nature of contract. Okay, before going into the concepts and this paper, first of all, ரெண்டு விஷயம். ஒன்னு, business law is extremely easy. I always find my students telling me that practical paper தான் madam easy. Theory paper is very difficult for us. Please understand, law is purely driven by logic and purely உங்களுக்கு வந்து these are only facts and நல்லா ஞாபகம் வச்சுக்கோங்க, what you have to do and what you don't have to do. That's all. எந்த law வேணாலும் எடுத்துக்கோங்க, எந்த ஆக்ட் வேணாலும் எடுத்துக்கோங்க. எதை பண்ணலாம், எதை பண்ணக்கூடாது. பண்ணக்கூடாத விஷயத்தை பண்ணா then what is the penalty, interest or consequences, what will happen in later, what are the procedures and all those things. எதை பண்ணலாம், what are you permitted to do. That's all. It is very simple. இன்னொரு small example கொடுக்குறேன். It's a quick example. இப்போ நீங்க வண்டி ஓட்டும் போது there is red light, orange light and green light. You stop, you get ready and you proceed. எப்பப்ப எது எது பண்ணணும்ங்கிறது உங்களுக்கு யார் சொன்னா? There is a separate motor vehicle act for it which will regulate traffic procedures and traffic rules and regulations which will tell you what you should do and what you should not do. That's all. இப்ப இந்த business lawsல நல்லா பாருங்க அந்த வேர்டையே, we are going to learn about laws which is relating to business. That's all. We are only concentrating on the laws and procedures which is relating to business, which will be useful when you become a CA in the future. Okay. One such law is Indian Contract Act of 1872. If you see, this has been enacted in 1872, even in British times, even before independence. And idhila vandu first we are going to see nature of contract. Okay, let's go into the chapter. Okay, meaning of contract. What is meaning of contract? முதல்ல contract na enna? Contract is nothing but agreement plus enforceability by law. இந்த ரெண்டுத்தையும் மறக்கவே மறக்காதீங்க. Okay, sorry, கோடை வந்து தப்பா போட்டுட்டேன். Okay, it is agreement plus enforceability by law. அந்த பிளஸ்ங்கிறது பாருங்க, இது வெறும் agreement மட்டும் இல்ல. This particular agreement should be enforceable by law. Tomorrow, when you want to enter into some litigation, you want to sue somebody, this particular agreement should be capable of suing the other party. That's the enforceability by law. Okay, we'll see step by step. What is agreement? See, again, the material that I'm using here is I prepared as a referencer. If you want to read more detail, you can refer institute material or any other author books that you want. This is just a referencer I made for this video. Okay. Agreement is nothing but offer or proposal plus acceptance. இதுலயும் பாருங்க, there is a plus sign here. Yeah. Why there is a plus sign? வெறும் offer மட்டும் பண்ணா போதும். There are two parties to a contract. ரெண்டு பேர் இருக்காங்க. So you're offering something, you offer to do or not to do something, and the other person is accepting it. So please remember, offer or proposal plus acceptance. Without acceptance, it can never be called as a agreement. And what is agreement? Section 2E defines agreement as every promise or set of promises. Oru promise mattum illa, multiple of promises forming the consideration for each other. Okay. Again, there are two parties to a contract. You say that you will do or you will not do something, and the other person says that what is the consideration I'm giving? What is the thing that I am bringing into the plate? Yeah. Okay. What is promise? When the person, see, இப்போ step by step பாருங்க, contractல agreement வந்தது, agreement பார்த்தோம், agreementனா offer or proposal plus acceptance. Agreementனா என்ன? Every promise or set of promises forming the consideration for each other. Now we are saying what is promise. When the person to whom the proposal is made signifies his assent thereto. Meaning what? He is accepting to the proposal that you have made. That's all. Okay, in the line ellarum ஞாபகம் வெச்சுக்கோங்க, proposal when accepted becomes a promise. Okay, and only when this happens in a structural basis, this becomes this becomes enforceable by law. This gives a rise to a legal obligation and duly enforceable by law. Okay, so we'll go very, very simple. There is every set of promise or promises that you offer to do to somebody, and that particular person is saying, yes, I accept your offer and proposal. It becomes agreement, and that agreement, when enforceable by law, becomes a contract. Easy? Yeah. Okay. So now we'll see what is the difference between agreement and a contract. So there is a difference. There is a basic difference. Very, very, very simple. When there is an offer, then there is an acceptance, then it becomes agreement. Yeah. If this particular offer plus acceptance agreement is enforceable by law, then it becomes a contract. That's all. That's all is the difference. So this comparatively is a wider term, okay, which will include both legal and social agreement. See, there are two types of agreement, legal and social agreements. Your father says, when you clear CA, I'll get you a car. It is just a social agreement. It is not a legal agreement. Tomorrow, when he says, son, sorry, I'm sorry, I don't have enough money, please get your own car. You cannot sue your father, man. It is just a social agreement. But when it becomes enforceable by law, you immediately get a stamp paper and write all the terms and conditions and get your father to sign the contract, and you enter, you being a major entering into a contract with the father, then it becomes legally enforceable. Now you understand the difference. So agreement is a wider term which will include legal and social agreement. But contract is used in comparatively a narrow sense with specification that contract is only legally enforceable. Any agreement which is not legally enforceable is not a contract. So what is legal obligation? Legal obligation agreement may not create a legal obligation because it is not duly enforceable by law. Yeah, it does not grant a legal right to enforce that particular agreement. As I told you before, only if it becomes enforceable by law, there is a legal obligation is created. And here, when do you call some agreement as a contract? When it is creating a legal obligation to creating a legal right to sue each other. The parties of the contract can sue each other. Then it becomes contract. So this is quite easy. All agreements are not contracts, but all contracts are agreements. Okay, moving on. Okay, now we'll see essentials of valid contract. Okay, before going into this, comparatively, your books and the institute book, everything is self-explanatory. Again, I'm telling you, this is just simple reference. Okay, so before going into this paper, I just want to highlight one main thing. What is that is, I want you all to start practicing. After listening to this video, I want you all to read the book once, read the material once, any material that you follow. There is no hard and fast rule that any material that you follow, and start answering the past exam questions from day one. Okay, let me be very, very specific here. From day one, if you start answering all the questions, you will have a better understandings of concept and the provisions which is given in this law. Okay, moving on. Now I'm keeping this particular video very simple for you to approach law in a very simple manner and understand this in a very simple manner. Okay, two parties. See, before going into essentials of valid contract, now you understood what is the meaning of contract. So it is very logical, man. If there is one party, how will you enter a agreement between, I know, yeah, between yourself? No, that cannot happen. So ரெண்டு கை இருந்தாதான் ஓசை இல்லையா? ரெண்டு கை தட்டினாதான் ஓசை, ரெண்டு party வேணும். Party A or party B, whoever it may be, there must be two parties involved in a contract, one making the offer and the other one accepting it. Okay, that offer can be anything. Okay, and a contract may be made by natural persons and by other persons having legal existence. Meaning what? Any artificial persons like companies, universities, They are not natural person. Who are called as natural person? Us, human beings. Okay. The law says it is not necessary only natural persons can enter into a contract. You can enter into a contract with your company. You can enter into a contract with your university. To any legally established university or legally established company, you can enter into a contract with. Okay. Uh, a case law is given here. This is quite a popular case law. On dissolution of partnership, the assets of the firm belong to the partners as the joint owners. Obviously, when they are conducting partnership business, the assets of the business belongs to all the partners within the partnership. When they are dissolving it, obviously the assets will be distributed among them. This can never be treated as a sale because the same person who has ownership in the property cannot sell the property to himself. It's not logical at all here. Yeah. Okay, I hope you understood this. Moving on, essentials of valid contract. Parties must intend to create a legal obligation. This is quite very obvious thing, man. I told you before, only when there is a legal obligation, only when there is a enforceability of law, sorry, enforceability of law, it can be called as a contract. But think about a small thing here. The intention, okay, the intention of the parties, both the parties, is to create a legal relationship between them. Okay, if the intention itself to create a enforceability by law should be there, that is one essential valid point in making a valid contract. Okay, any kind of social and domestic kind of agreements between father and son, or I've given a case law here where there is an agreement, social agreement between husband and wife to pay maintenance, will not hold good. Yeah, because there is no intention to create legal obligation, and there is no legal obligation because it's not enforceable by law. Okay. Other formalities to be complied with in certain cases. A contract may be written or spoken, although the law does not mandate the contract to be written. Please understand, the law says even oral contract will hold good. But what is the irony here? The law says it will hold good, but it still says that it has to be written for you to go to the court and sue that particular person. Okay, so the contract should definitely be written to be legally enforced, and few are mandatorily registered, like contract of insurance. If you are buying a immovable property or selling an immovable property, obviously you will create a sale deed and go register in the sub-register officer and transfer the property from your name to the other party's name for a consideration. Yeah, this is quite obvious. Certainty of meaning. The agreement must be certain and not vague or indefinite. See, this is also quite logical, man. Let's assume you're entering into an agreement to sell some dal. You cannot say selling dal. You should say what is the kind of dal, how much quantity, how it will be packaged. It must be certain. There should not be any vagueness and ambiguity there, and it should not be indefinite. Yeah. Okay. Moving on. Possibility of performance of an agreement. This point is quite interesting, man. If you see, if you're entering into a contract of doing something, then there should be a possible scenario to perform the contract. If it is really impossible to perform some contract, you say that I'm going to go lift a mountain. Is there any possibility in lifting a mountain by yourself? Obviously, no. There is an impossible scenario here. Yeah. Okay. So the terms of the agreement should be capable of performance. We already saw agreement is offer or proposal plus acceptance, and what is promise and what is agreement. We saw all these points earlier. Free consent. You should not force anybody to enter into an agreement with you. Please understand. That does not hold good in the eyes of law. There should not be any coercion, any undue influence, or fraud, or misrepresentation, or mistake. You cannot threaten somebody. You cannot morally put them down and make them sign that contract. All this is not acceptable in the eyes of law. Free consent, free and clear consent. Okay. Identity of minds. Identity of minds is This is quite interesting. See, let's assume you're entering into a contract with somebody. You think something in your mind and entering into a contract. That particular guy is thinking about something in their mind and again entering into a contract. This will obviously not hold good because you don't have consensus here. There is no identity of minds here. Okay, so when both person are entering into the contract, they should be very clear in what each other's responsibility with respect to that particular contract. Is that clear? Yeah. Capacity of the parties. This is also obviously this is pure logical. If you are of an unsound mind, if you are disqualified by any other act, if you have not attained the age of majority, what is age of maturity here? 18. When you're below 18, you are considered as a child. You're not a major, you're a minor. You cannot enter into a contract. Anybody who is not having a sound mind cannot enter into a contract. So these are the people, these are the capacity which is necessary for you to enter into a contract. Consideration. This is also logical. If you think about some, nobody is doing charity here, man. You're buying something, you're selling something. What is the consideration that you get? Money. Or instead of money, if you're going to get some other consideration, that will hold good too. But there should always be, remember this word, quid pro quo. Quid pro quo. Not only in law, in everything, there is always a catch. There is always something in return. The other person is not doing you a favor unless they are your relative or friend or whoever it may be who is, who does things for you. That's a totally different scenario. But always there is a catch. Always you have to give something in return. Please understand. And as per law, a valuable consideration may consist either in some right, interest, profit, benefit. It can be of anything, or you're forbearing something. There is a forbearance, detriment, loss, or responsibility given. It can be of anything, man. Okay. You doing something is also a consideration. You not doing something is also a consideration. Okay. Yeah. Lawful consideration and object. The consideration which we spoke earlier should be lawful, and the object of that particular contract should also be lawful. Okay, meaning what? You should not enter into a contract for doing things which are unlawful, which is not accepted by law, which is prohibited by law, which will defeat the provisions of law, which will involve a fraudulent action, which will involve a injury to other person or a property or any immoral or opposed to public policy. You should not do all these things. You cannot enter into a contract for performing any terrorist act, or you cannot enter into a contract for money laundering. These are all something which is unlawful, prohibited, and which will defeat the provisions of law. Okay, not expressly declared to be void. This void word itself is quite interesting, man. What is the meaning of void? What do you think void is? Void meaning the agreement, the contract will not have any, what do you say? It is declared to be void. It cannot be enforced. There is a proper offer, there is a proper acceptance, and it is enforceable law. By law, everything is perfect. Yeah. Later, there may be unfortunate circumstances which will render this particular contract to be void. Meaning what? This contract cannot be enforced. Okay. It can happen something which is suddenly given by an unfortunate incident, or suddenly that particular act, object of that particular contract can be prohibited by law. Anything may happen. Okay, the agreement entered into must not be which the law declares to be either illegal or void. These two things are totally different. Okay, the contract should not be illegal or void. When you're entering into a contract, see, there is a difference here. When you're entering into a contract, it is not necessary that you will know that tomorrow this particular contract will become void. It may go void or it may not go void. It's a different thing. But if you're entering into a contract which is illegal, then it is void ab initio. At the time of entering itself, it is void. You cannot enter into a contract which is illegal. So there is a difference here between an illegal contract and a void contract. An illegal agreement is an agreement which is expressly or impliedly prohibited by law, and void agreement is one without any legal effects. Meaning you could not execute the contract, that's all. You may not have any legal implication. Nobody is going to sue you because it's impossible to execute that particular object of the contract. Yeah. Okay. Now we saw essentials of valid contract. Can we revise it once? So what are the essential things? There must be two parties. Parties must intend to create a legal obligation. Other formalities to be complied within certain cases. Certainty of meaning, possibility of performance, free consent, capacity of the parties, consideration, lawful consideration and object, not expressly to be declared as void. These are the essential. So essential characteristics for a valid contract. These are the essential characteristics. Okay, next is types of contract on the basis of validity. You can categorize contract on couple of bases, on the basis of validity and on the basis of formation of contract, on the basis of performance of contract. First, we are going to see on the basis of validity, whether that particular contract is valid or not. So valid contract is what? First, we'll see valid contract. Valid contract is something which has all the essential characteristics of that we saw earlier. This is valid contract. What is void contract? Which ceases to become enforceable by law, or there is an impossibility of a performance, then it becomes void contract, meaning the case is done. What is voidable? There is a difference between void and voidable, which we'll see in the later parts. But what is voidable is, again, we'll go to the basics. You're offering something, the other party is accepting. While accepting, that party, let's assume that party is getting influenced by coercion, undue influence, fraud, it can be whatever thing. So that particular party is called as the victim because that guy has been threatened and made to accept. Yeah. So he is the aggrieved party. Then now he has accepted, technically the contract becomes valid, but the consent is not free consent. Then he has an option. Who has the option? The one who is aggrieved. That guy has an option not to execute this contract because he has been threatened, influenced, on a fraudulent basis, he has been forced to accept this. So there is an option to the agreed party to make this contract voidable. Now, do you understand what is void and voidable? Okay. See, again, this point is quite interesting. The law says add the option. So even if you are threatened, you say, it's okay, let me go through the contract, then you're not exercising your option. It becomes a valid contract. But you're exercising your option and saying that, no, this contract is void. So why it is called as voidable? Because you have this option to make this contract either valid or void. Is that clear? Okay, illegal contracts we saw earlier. It is forbidden by law. There is no, there is no any proper, it is clearly forbidden by law. It is clearly prohibited by law. Okay. And look here, this is quite interesting. All illegal agreements are void, but not all void agreements are illegal, right? Yeah. So again, we'll see what is the difference between illegal and void contract later. Unenforceable contract. When a contract is good in substance, but because of some technical defect, like absence in writing, barred by limitation, one or both the parties cannot sue upon it, then it is not enforceable by law. Once it is not enforceable by law, then you cannot call it as a contract at all. See, obviously there will be some typo errors, there will be some mistakes, and sometimes it will be barred by some other act. Some other act will come into the picture and say, no, you're not supposed to do it while executing this contract. This particular act is getting violated, then it becomes unenforceable. All those things will happen. This is quite common. Yeah. Okay, I hope you understood. Valid, void, voidable, illegal, and unenforceable contract. We'll quickly see what is the difference between void and voidable. We already saw it. A contract, when ceases to become enforceable by law, it becomes void. But here, there is an option to the aggrieved party to make this contract void or valid. So when there is such option, when he's been threatened and made to accept the offer, then it is called as voidable contracts. This is not enforceable by law. This is enforceable at the option of the aggrieved party. Reasons of contract becoming void or due to circumstances. It can be of anything, man. Sometimes, suddenly COVID came into the picture. We all know COVID. Okay, there are many contracts which was entered, 1 month before the COVID period, which could not be executed, being an unforeseen natural calamity. It's a disaster. So, things cannot be, many contracts were not being executed due to COVID. Okay. The reasons of contract being voidable is when one party's consent is not obtained freely. Okay. Here there can be no performance, and here why it is said as it can be performed, because there is an option to a aggrieved party to make this contract valid or invalid or void. When he considers that, when he chooses the option to make this contract void, then it becomes a void contract. You cannot perform. When he opts for the option saying that it's okay, even if I've been threatened, it's okay, let's execute the contract, it's good for me, then the contract will be performed and it will become a valid contract. Moving on. Rights and consequences. There is no legal remedy because there is unfortunate incidents which becomes, at no fault of either of the parties. Here, the contract can be rescinded, cancelled. Yeah, the contract can be cancelled if the aggrieved party within reasonable time. Again, if you see here, the law says reasonable time, but it does not say what is a reasonable time. So it is considered to be a small gray area. Reasonable time is probably, we can say that, let's assume somebody has to give you money and right, after 3 years you cannot ask him because it will be barred by limitation, things like that. So that reasonable time should be exercised here, and the right to cancel the contract should be exercised by the aggregate party within the reasonable time. Yeah. If the right exercise, then it becomes a void contract. Again, I told you, if not, the contract is very much valid. Next is void and illegal. This is very easy, man. All void agreements are necessarily, it's not illegal. But all illegal contracts are void ab initio. Void at the time of, and what is void ab initio? At the time of entering the contract itself. It's not forbidden by law. It's clearly forbidden by law. It's not punishable. There is a liability of punishment. Obviously, man, it's illegal. Collateral agreements to a void agreement can be a valid agreement. Yes, because any agreement which is attached to a void agreement, if it can be performed, then it is as good as a valid agreement. But if there is a collateral agreement with an illegal agreement, ஒரு துளி விஷம்னாலும் பால் கெட்டு போனதுதான். ஒரு குடம் பால்ல ஒரு துளி விஷம், அந்த மாதிரி தான். Any collateral contract along with the main contract which is illegal is considered to be illegal and void. Yeah. Okay. Types of contract on the basis of formation. Okay. This is very simple. What is express contract? You expressly say whether, what is the proposal, what is the acceptance, and it is clearly given in writing. What is implied contract? Implied in the sense there is no expressly written words or expressly saying that this is the proposal or acceptance. It's not clearly expressed. Instead of doing that, what they're doing, they are implying something by action or conduct of parties. See, this is quite easy. See, when you get into a bus, when you get into a parliament bus, you enter into it is implied that you have to buy the ticket from the conductor and then reach the place. You have to get down in that particular stop where you have bought the ticket. It is implied. Nobody talks. He doesn't comes and ask you anything. You don't go and talk to him. It's implied. The moment you get into an auto, It means you are asking him to take you to the place where you want to go, and you're going to pay the money for him. Yeah. These are all actions and conduct of parties which implies of entering into a contract. Okay. So implied can also be called as tacit contract. Tacit means silence. What is quasi contract? Quasi itself means half this, half that. It is not an actual contract, but resembles like a contract. The law creates and enforces legal rights and obligation when there is no real contract exists. The law has the power when there is no legal contract exists between the party, but still it mimics the contract which is entered by them. Then laws will create a legal right and obligation between them, and it is called as quasi contract. What is e-contract or cyber or EDI? Nothing, man. If you send offer and acceptance through email or any electronical mode, it's called as e-contracts. It's very simple. There are many contracts which is entered like e-commerce. What is e-commerce? All this Amazon, Flipkart. When you say buy now, then you're entering into a contract between between the e-commerce platform and yourself, saying that yes, I'm going to buy this particular product. Then you're accepting all the terms and conditions. That particular product is returnable. It is returnable in 15 days, or it is not returnable. It is not delivered to your particular place. There's so much terms and conditions which comes along with that. Yeah. So that's called as e-contract. Next is types of contract on the basis of performance of contract. Okay. How you are going to perform that particular contract. The consideration given in a contract could be an act or forbearance. That is, you can or cannot do something. When the act is done or executed, or the forbearance is brought on record, then the contract is executed, meaning both the parties have executed the contract, meaning both the parties have done their particular jobs which they have already entered into a contracted for. Okay, what is executory contract? In an executory contract, the condition is reciprocal promise or an obligation. Meaning what? The consideration is to be performed in future only. It cannot be performed immediately. And therefore, these contracts are called as executory contracts. There are many such contracts like that. You know, I am doing a favor to you today. Tomorrow, when you grow up and earn more money, you have to return back this much amount of money with this much interest. So the contract is creating a future obligation which can only be done after 10 years or after 5 years, depending on what is the contract. Yeah. So again, here in executory, there are two kinds of executory contract. One is unilateral and another one is bilateral. What is unilateral? It is a one-sided contract in which one party has performed this duty or obligation, you can call it whatever you want, and the other party's obligation is outstanding. What is uni? One part is done and other part is pending. What is bilateral? Where the obligation or promise is outstanding on both parties. Let's assume when both parties has done their part, then it becomes executed contract, not executory contract. Meaning the contract has been done. It is half done here. Either half done or both the sides they have not done. Okay. Yes. So now we are going to the next part of the unit, proposal or offer. What is proposal or offer? When one person signifies to another his willingness to do or to abstain from doing something with a view to obtaining assent of that other to such act or abstinence, he is said to make the proposal. See, this is like, Bayangarama Sutirkaya. It is very, very easy. There is nothing great here. Meaning, one person is offering something. We'll see this analysis one by one. Promiser or offerer. It is not necessary for you to repeat the section or the exact words which is given in the section. If you can, then great. There is nothing greater like that. Please go ahead and do it. But what I would suggest as a faculty is, please understand the concepts and what is a proposal, and please use the right keywords. Like if you see this analysis of definition, each part of this particular definition which is given under this section is clearly analyzed. If you remember this analysis, it's more than enough. Okay. The person making the proposal or offer is called as offerer. The person who the offer is made is called as offeree. And promisee or acceptor yaru? The person who is accepting this offer is called as promisee or acceptor. Okay. For a valid offer, the party who is making the offer must express his willingness to do so. Meaning what? He should clearly state that I am willing to make this offer. I am willing to do something or not to do something. This is my offer. Will you accept it or not? Or please accept it. That's all. The willingness must be expressed with a view to obtain assent of the other party. Meaning what? When he is making the offer, he needs to have the willingness to do something or not to do something in order to obtain the acceptance of other party. It's very simple, man. A guy proposing to a girl, yeah, he is making an offer. Will you marry me? He will have absolute willingness to get her acceptance to say yes, to make her to say yes, right? You can understand it as simple as that. An offer can be positive as well as negative. Yeah, I know. It can be to do something or not to do something. You know, both can happen. Both is an offer. I hope you understood this. So this is section 2A, which defines proposal or offer. What is classification of offer? This offer is again classified into general offer, special or specific offer, cross offer, counter offer, standing or continuing or open offer. Okay, we'll see it one by one. The word itself will explain you, man. What is general offer? You are making this offer to everybody, not one person. On public, by large, on public, you are making this offer. Yaar venalum vaanga அப்படிங்கிற மாதிரி. It is an offer made to public at large, and hence anyone can accept it and do the desired act. Okay. Let's assume you're listing your company in stock exchange, and you're making an offer to the public at large to subscribe the shares of your company. Meaning what? Anybody can accept the offer and buy the shares of your company. It is as simple as that. Okay. Here, this particular case law is quite interesting. This guy, what he does is, see, this particular case law is from 1893, where the company advertised a reward for users of smoke balls according to the printed directions who have contracted influenza. Do we have influenza now, or there is a vaccination? I don't know. Okay. So what one lady does, this Mrs. Carlyle lady does is, she used the smoke balls as per the directions of the company, and she suffered from influenza. Because of using this particular smoke balls, this lady got influenza. This lady is very much eligible to get compensation from this carbolic smoke ball company. That guy cannot say that no, I didn't make the offer to you, because the offer is general offer for public at large. He has advertised that on a newspaper, a reward. So this lady is very much entitled to this reward. Okay, so this is general offer. Okay, what is special offer? Special offer is like proposing to a girl or proposing to a boy, whomever it may be, to a specific ascertained person, not for a public at large. Is that clear? Can only be accepted by that specified person. See, let's assume when you're proposing, there is a friend who is sitting next by her. She cannot accept you, man. This girl should accept you. Yeah. So it's as simple as that. This is explained clearly in Bolton versus Johns. This is one more case law here. What is cross offer? When two parties exchange identical offers in an ignorance at the time of each other's offers. This is quite interesting. See, meaning there is A, there is B. This guy says, please buy my car for 2 lakh rupees. This guy says that, please let me purchase your car for 2 lakhs rupees. See, if you clearly, this is quite interesting. If he clearly says, both the people are in ignorance, saying that the same offers is done by both people. Okay. The offer is identical here. But tell me one thing, is there an acceptance? No, because both are offering each other and there is no mutual acceptance, man, here. Let's assume if this guy has done the offer and he has accepted us and there is a valid agreement and contract enforceable by law, all those things. Both people are doing offers at the same time, not knowing each other is going to make the same offer. There is no acceptance here. So there is no binding contract in such case because of this offer made by the person and cannot be construed as an acceptance. Okay? Yeah. Next is counter offer. This we do every single day. Yeah. You go to a vegetable stall and you buy vegetable. That guy says half kg carrot is 40 rupees. You say, Anna, please give me for 25 rupees. So now tell me, you are rejecting the original offer which is made by the vegetable vendor for 40 rupees and you are giving a counter offer. Not acceptance. If you accept 40 rupees and say that, okay, I'll buy for 40 rupees, it is acceptance. You're only counter offering, you're bargaining and saying that, no, please give it for 25 rupees. If he accepts it, then it becomes a agreement. Okay. You are essentially rejecting the original offer and there is a conditional acceptance. What is the condition? Only if you reduce the price to 25 rupees, I will buy the vegetable. Okay, what is standing or continuing or open offer? An offer which is allowed to remain open for acceptance over a period of time. It's called a standing offer, meaning what? Tenders for supply of goods is kind of a standing offer. Very, simple thing is when you say that I'll wait for you. My offer still opens. My offer still stands. It means what? Standing offer. It is a continuing, it is open. The offer is not closed. The case is not closed. You're still waiting for the execution of that particular contract. Yeah. Okay. So we saw what is the classification of offer. Let's revise it once. General, specific, cross offer, counter offer, standing or continuing or open offer. These are all very simple, man. There is nothing great in this. Okay, essentials of valid offer. Before we saw essentials of valid contract. We are now seeing essentials of valid offer. Okay, it must be capable of creating legal relations. The same point. It must be definite and not vague. Yes. It must be communicated to the offeree. This is interesting, man. Let's see this. See, only if you communicate to the offeree, then she will know, she or her or whoever maybe, they will know that there is an offer. Without you communicating anything to the other person, how will they know? Okay. Otherwise, there is no acceptance of it. Correct? An acceptance of an offer in ignorance of the offer is not acceptance. Please understand it. Let's assume I'm offering something to the other party without even knowing what it is she is giving an acceptance. It is not considered to be an acceptance and does not confer any right of the acceptor. See, this case law is very interesting. This guy G is sending his servant L to trace his missing nephew. While he's searching, while this L searching the nephew, this guy has announced a reward for finding his nephew. But L does not know that this particular guy has has announced a reward. What he does is he has already traced the boy and brought him back to the home. And later, this guy comes to know that, okay, there is a reward and he is asking a reward to G. This guy clearly says, obviously, I have not communicated my offer to you. So there is no acceptance of the offer. You cannot ask me for reward. Interesting, no? Okay. So please understand, once it is communicated to the offeree and he has accepted, it is done. But there is an ignorance in offer and the acceptances of offer cannot be taken as an acceptance at all. It must be made with a view in obtaining the assent, the same point, man. Okay, and not merely to a view to disclosing the intention of making offer. See, there is a difference, man. Making an offer is different from intention of making an offer. Okay, When you disclose the intention of making an offer, it doesn't mean that you have made the offer. Okay, let's be very, very clear. When you go to I'll give you a small example. When you go to a store, you ask what is the price. Okay, you cannot say that because he has opened the thing together. Let's assume you are asking a price, asking the inquiring about the price. It doesn't mean that that particular guy is offering you to buy the product. He is just replying to you saying that the price of this product is this much. Only when he offers to buy, can you please buy it, sir? Then he is making an offer and he is quoting the price. So there is a difference. Intention of making an offer and making an offer. Okay. Then it may be conditional, subject to any terms by the offerer. See, there is lot of terms and conditions which will come along with the offer. It is accepted. It is a valid offer. Offer should not contain a term of the non-compliance of which would amount to acceptance. Thus, one cannot say if acceptance is not communicated by a certain time, the offer would be considered as accepted. This is not accepted, man. Okay. See, when there is an offer, the one who is offering cannot say, let's assume I am making an offer to you. Within 15 days, if you don't respond, then I will take it as acceptance. No, this cannot happen. Okay. There should be an offer and clearly there should be an acceptance. He cannot presume that if you don't reply in within 15 days, then I take it as acceptance. See, you may ask, madam, you said the offer is conditional. Can we take this as one of the conditions while making the offer? No, this is not a condition. No, this is containing a term of non-compliance, which will tantamount to acceptance. No, this cannot be accepted. Again, the offer can be for a specific person or a general. It can be expressly stated or implied by action. These are all accepted. Yeah. Here, point number 9 is quite interesting. I have given 3 points along with this. Okay. So offer is different from statement of intention and announcement. Again, I told you, intention of making an offer is different from actually making an offer. Yeah. Offer must be distinguished from an answer to a question. When you're asking a question and that guy is answering, that doesn't mean he's offering. He's only answering for your question. This particular case law is quite interesting, man, where the plaintiff sued the defendant, contending that they have made an offer to sell the property at 900 pounds. No, because the Privy Council, see the judgment here, did not agree with the plaintiffs on the ground that plaintiffs had just asked the question. What are the two questions? Will you sell us your pen? What is the lowest price that you can offer? Both has been answered by the defendant saying that the price is 900, and they have not replied only to the second question, and the first question, will you sell us your bumper hall pen? They have not expressed their acceptance. So there is no offer at all. Okay. So it should be clearly distinguished between intention to sell and intention of making an offer and actually inviting or making an offer. Sorry, my handwriting is not clear here. Okay. Similarly, there is again a case law which will explain the same thing here. Okay. Next is a statement of price is not offer. We saw this earlier. Stating a price is not an offer. An invitation to make an offer or to do business again is not an offer. The person sending invites to other party to make an offer, meaning you're requesting him to make an offer. See, this clear example is red herring prospect, any prospectus for matter, or goods sold through auction. Meaning, this particular prospectus is issued by the company, meaning he is only inviting the public to make an offer to subscribe the securities of the company. Okay, there is a difference. So you have to say that, yes, I'm willing to, I'm making an offer. This is my offer. Please accept it. Later, the company will accept it and allow you to subscribe the shares of the company. Okay. Yes. Just 2 more minutes. We'll close this. A statement of price is not an offer. Again, we have seen this many times. We are going to quickly see what is the difference between offer and invitation to offer. Section 2A clearly says that an offer is a final expression of willingness. Sorry. Let me correct it here. Okay. By the offerer to be bound by the offer should be the other party chooses to accept it. There is a clear final expression of willingness by the offer with an intention to do or do not, not do something, and the other party chooses to accept it. Then it is a clear cut offer. There is agreement, there is offer, there is acceptance, there is enforceability by law, then it becomes contract. Invitation to offer is without expressing his final willingness, proposes certain terms. That's all. That's all. Where he is willing to negotiate, he does not make an offer. Please understand, he is only willing to negotiate and he is not making a final offer, but only invites the other party to make an offer. See, I have given few examples here. An invitation by a company to the public to subscribe for its shares, display of goods in shops window, and advertising for auction sales, quotation of prices. You know, you make a query with regarding to the prices of the product, and the company replies. It's as simple as that. No, it is only a invitation to offer. Okay, intention of parties. This is quite important, man. This intention of the parties is very much valid in a valid offer and valid contract. We saw this intention in both essential characteristics. If a person who makes the statement has the intention to be bound by it as soon as the other accepts it, then he is making an offer. Very simple. If the person has the intention of negotiating, then he is only inviting you to offer. An offer cannot be a precedent to a invitation to offer. Obviously, man, which comes first? Kodi vandida, mutta vandida. Invitation to offer will come first. Invitation to offer will come first. An offer will follow that. Okay, first is invitation to offer. And offer will follow after that. After you negotiate the price, after you discuss all the terms and conditions, then you offer. Okay. This is part 1 of unit 2. Thank you for listening to me. I hope this video was useful to all of you. Thank you so much. See you on my next video. Bye.